Hello and welcome back to part 2 of chapter 3. Let's get back into it. Before introduced in 1967, employers and employees were encouraged to settle their disputes based on two ordinances. Industrial Courts Ordinance 1948, Voluntary Reconciliation through Third Party. Trade Dispute Ordinance 1949, Voluntary Arbitration by the Industrial Court. The Industrial Relation Act allowed the government to intervene and settle disputes between employers and employees, thus promoting a harmonious and mutually beneficial relationship. Under the Industrial Relation Act 1967, the paid annual leave does not include public holidays. An employee must take his annual leave not later 12 months after the end of every 12 months of continuous service. If he fails to do so, his annual leave will be forfeited. The whole or part of the untaken annual leave may be substituted for payment at the request of the employer and with the written consent of the employee. An employee's annual leave can be forfeited if he absents himself from work without permission, or without any reasonable excuse for more than 10% of the total number of working days during the 12 months of continuous service for which his entitlement is accrued. If an employee's service is terminated, for reasons other than misconduct, or if he resigns by giving due notice, he is entitled to the ordinary rate of pay in lieu for the completed months of service. If an employee who is on annual leave falls sick, or is on maternity leave, the employee is entitled to sick leave or maternity leave as the case may be, and the annual leave already taken by him or her becomes cancelled. The Part 2 of the Industrial Relation Act 1967, where it protects the rights of workers, employees and trade unions, consists of Section 5, where employers cannot prohibit workers to join trade unions, or TU. Terminate workers who join TU. Overrule the application of workers who join TU, and force workers to join TU. This involves two main parties. The first will be the Malaysian Employers Federation, or MEF. Also the Malaysian Trade Union Congress, or MTUC. In a nutshell, the Industrial Relation Act 1967 helps on protection of rights, collective bargaining and collective agreements, as well recognition and trade union scope. The next we'll talk about is the Children and Young Persons, Employment, Act 1966. This act prohibits children from working near hazardous and poisonous materials. No child, where is defined a person under the age of 15 years or young person, where they are in between age of 15 years and under the age of 18 years, should be engaged in any employment shall in any period of 7 consecutive days be required or permitted to work for more than 6 days. For child person only required to work not more than 6 hours in a day, and for young person only allowed to work maximum 7 hours per day. Under Employment, Restriction, Act 1968, non-Malaysian citizens are required to obtain a valid work permit before they can be employed locally. Working without a valid work permit is strictly illegally under the Immigration Act 1966. Now we'll talk about the Occupational Safety and Health Act 1994. This act, which provides the legislative framework to secure the safety, health, and welfare among all Malaysian workforce and to protect others against risks to safety or health in connection with the activities of persons at work. Section 15 outlines the duties of the employer, includes maintenance of plant and systems that are safe and without risk to health, provides information, instruction, training, and supervision to ensure the safety and the health at work. Section 16 requires the employer to formulate safety and health policy at the workplace and regularly revise the policies to align the policies with changes and best practices in the business world. When excessiveness occurs, employer may decide to lay off some of his employees. It should be done in consultation with relevant labor union, if company is unionized, and with Ministry of Labor and Manpower. Apart from retrenchment, employer may limit overtime, limit work during weekly rest days, reduce number of shifts or work days per week, reduce working hours, and retrain and/or redeploy employees. The final decision to retrench the workforce depends on employer. If unavoidable, fair procedure must be followed as below. Inform as soon as possible to employees. Suggest a voluntary scheme for retrenchment and retirement. Pay retirement benefits. Assist to search other job. Employers normally cooperate with Ministry of Labor and Manpower on this matter. Delay termination process. Ensure that the announcement not be made before informing the employees or unions. Apart from wages, the Employment Act 1955 also covers on employees' right to unionize. Notice to terminate a contract. Termination for misconduct. Breach of contract. Payment of wages. Wage periods. Advances on wages. Deduction from wages. When wages no need to be paid. Priority of wages. Employment of women. Maternity protection. Working hours and leave. Rest day. Maximum working hours. Public holidays. Annual leave. As well on sick leave. Wages defined as basic wages and all other payments due under the contract of service excluding to the following, but not limited to: annual bonus, overtime payments, commissions, survival allowances, traveling allowances. There is no clause in a contract of employment which restricts the rights of an employee to join trade union, to participate in activities, or to join with others for purpose of forming a union. Employment Act, Section 8. Under Section 5 of Industrial Relation Act 1967, employer cannot prohibit workers to join trade unions, terminate workers who join trade unions, overrule the application of workers who join trade unions, force workers to join trade unions. In terms of notice to terminate a contract to employees, Section 12 of the Employment Act mentioned, either party to a contract of service may at any time give to the other party notice of his intention to terminate such contract of service. Employees can terminate contract at any time, with any reason or no reason. But employers could not do so, however, providing with proper notice. There are two provisions on notice of termination of a contract of employment. The first provision will be employers can decide on the notice period and agree to in contract of employment. If no clause in the contract, then the provisions of Employment Act will apply. Section 12 states the following clauses. For workers working for less than 2 years, the notice period will be defaulted to 4 weeks. For workers working for more than 2 years but less than 5 years, the notice period will be defaulted to 6 weeks. For workers working for more than 5 years, the notice period will be defaulted to 8 weeks. The second provision will be either employer or employee can terminate a contract without giving notice if he pay to other party an indemnity, sum of money equivalent to the amount of wages which would have been earned during the notice period, as referenced in Section 13. Employer has right to disallow employee from working during the notice period and pay him the indemnity even though notice have been given by employee. For termination for misconduct, Section 14 of the Employment Act gives right to employer to dismiss, downgrade, or impose any other lesser punishment on an employee after the holding of a due or domestic inquiry, is found guilty of misconduct. Employer can suspend employee from work to facilitate investigation or for any other reason, which is a maximum of 2 weeks. During suspension period, employee entitled to half of his wages. If found not guilty, the remaining half pay must be paid back. For breach of contract, as referenced in Section 15 of the Employment Act, if an employer fails to pay wages as required by the relevant section on wages, then he is guilty or on breach of contract. Employees can resign without notice if employers intentionally refuse to pay. They can claim constructive dismissal. More commonly, employees are found to breach the contract by being absent without permission. As Section 15(2) mentioned, employees continuously absent from work for more than 2 consecutive working days without prior leave from employer are considered breach of contract unless with reasonable excuses. That's all for now. We will continue the other coverages of the Employment Act 1955 on the next lecture. We hope you understand and we'll see you in the next lecture. Thank you.